welcome everybody. I don't need to introduce myself. I just wanted to mention I'm professor of law. I'm not a technician, and in recent years I was very much involved in different ways with the legal framework of AI. If you are interested in what our institute is doing, I just refer to our website, LegalInformatics Saarlandes. In our institute, we are involved in almost all aspects of technology and law, including, of course, and a special focus being on AI. Let's address today's topic. After a very short introduction into some challenges, I would like to introduce what the European Commission mainly and the other organs of the European legislator are doing recently on creating a legal framework for AI. And there's some interesting new developments which might be worth considering. I don't have to go into the pros and cons of AI, since that has been discussed yesterday in much more detail, so I just skip this. What I would like to briefly mention is that AI is challenging our traditional law. For instance, it is just the buzzword creative AI. Now, recently we don't have the traditional question if animals are being able of being creative and if their works are protected, such as if they take a picture. Nowadays we discuss if paintings created by AI systems are protected by copyright, and they're actually at this moment they are not. AI is challenging the doctrines of legal transactions. Is a contract made by an AI system valid? And what if there is an error on the side of the AI systems if the intelligent fridge is ordering 40 instead rather than 4 liters of milk, for instance? That is posing an enormous challenge to our legal doctrine of contract law, as traditionally we refer to a human mind made or human-made decisions. The European Parliament went as far as suggesting new legal institutions, such as the introduction of an e-person some years ago. At this moment, this development doesn't go further, but it will certainly come back in a couple of years. Do we need some completely new kids in the block regarding the legal the legal framework? That will certainly be the case, I think. How will our societies work? Will we see some kind of partnership of human and machines? What we actually see at this moment already is what I call a partial equality of AI systems and humans. In some cases, we tend unconsciously sometimes even address machines the same way as we do with humans. And of course, there are risks from the accidents caused by an AI system to software making improper statements. Some years ago, the chatbot Tay, which was released by Microsoft, after a few hours of operation only, started making statements which were criminal offenses if made by a human. So how do we deal with that? And of course, we are concerned about discrimination by AI systems and the machine, the bias, which was already mentioned. So how do we cope with all these challenges? We need probably a European legal framework, as it was said yesterday and in the introduction already. I just want to, from my position, to highlight the need for an adequate legal framework by an interesting example. Some years ago, 2016, a very breathtaking study was published about the social dilemma of autonomous vehicles. This is well known, the new version of the classical trolley problem based in the question if an accident is not unavoidable, and the autonomous car would have to make a decision whom to injure, who should be chosen. And it was interesting that in a survey of about 1,000 people, the authors asked people the option if the car should sacrifice its own driver rather than killing pedestrians. And that was the most important question. What do you think people said? The first question was, what is the right decision? And then the majority declared that rather than killing a bigger number of people, the car should sacrifice its driver. However, then later, next question was, what kind of car would you like to buy? The selfish car, protecting the driver in any circumstance, or the moral acting car, sacrificing the driver in some case? Well, majority honestly said, maybe I would prefer the selfish car, protecting myself. And then the interesting question was, should the legislator intervene and make a relation on this decision making? And then a clear majority, yes, was against regulation of this. And now I'm asking you, what do we learn from this as lawyers? I give you my analysis. We must regulate, since if we do not regulate it, then car makers will produce selfish cars. And those cars is not what we want to have on our roads. Actually, in Germany, the German legislator already intervened here and explicitly prohibited the use of car making such choices. In Germany, at least, there is a broad majority in favoring legislation. In a survey among German businesses, 90% of the people voted for a legal framework of liability in particular. Also, most of them, 76%, was concerned about hacking, and the vast majority again wished some regulation on safety. And that the European legislator has been aware of that need for legislation and was extremely active in recent years. The starting point I already mentioned was the European Parliament's resolution of 17 with recommendations on civil law rules on robotics, including far-reaching aspects such as the introduction of e-personhood and others. Probably you're aware of the European system. On the European level, there we have three main organs which together form the European legislator, which is the European Parliament, which has a traditional function of Parliament, the Commission, which is the European government, and the Council, which is the second chamber of the Parliament, if you wish so, in comparison to traditional national systems. And it was the Commission who is driving the development from 2018, when it's published its strategy, II for Europe. Surprisingly and unusually for such a strategy paper, the legal framework played an important role in this strategy paper. Following the publication of its strategy, the European Commission founded several expert groups, among those an expert group on liability and new technologies, which published a final report which might be worth your attention in December 2019. European Parliament came along with another resolution, including a proposal for regulation, so a European law on civil liability for AI. What you will probably know, since it was discussed almost worldwide, is the European Commission proposal for the so-called AI Act. I will come back later to it. And the most recent proposals are a proposal for directive on liability for defective products, which would be a new, updated, renewed product liability directive, and at the same day, a proposal for directive on civil liability for artificial intelligence. And this, the most recent documents will be part of my analysis. Now let's turn to the draft AI Act. It was published in April 2021, so 2 years ago. It has been intensively discussed since then in the Parliament. We had more than 3,000 suggested amendments before and the Parliament is expected to make up its mind this month. We have a preliminary version of the Parliament's vote from April, and the final decision of the Parliament is expected for June. The Council, the representation of the member states' governments, made its or finalized its general approach last December, and from June or July on, we will have this so-called trialogue where the Council, the Commission, and the Parliament will make the final, enter into the final debate and the final drafting of the Act. And some of us expect the enactment of the AI Act this year already, maybe December this year or early next year. It will then be applicable from 2027. So possibly we will have a new important piece of legislation in this field. It's not a comprehensive legislation, even though it covers 12 chapters, including of 85 articles. So it's a massive piece of legislation compared to others. What does it contain? First of all, it makes a definition of AI. However, it doesn't refer to AI as such, rather than being applicable to AI. It refers to AI systems, which is a good choice in my view. And AI system is a system consisting of software or hardware, but even pure software can be an AI system, which was produced by using technologies which can be summarized as artificial intelligence. And that is and the definition here is very broad. Apart from that, the AI Act contains 4 different types of legislative concepts. First of all, it prohibits the use of certain AI practices in its Article 5, but that's only a very short list, so-called black list of AI practices. That is certainly rightly protected. There's not much debate on this. The biggest part and the most important part of the AI Act is related to the so-called high-risk AI systems. And here, the AI Act in about 45 articles is addressing and is outlining a quality management system, a risk management system, and is obliging the producer and user of AI systems to minimize risks associated with their AI systems. There are, again, in a very short chapter comprising of 1 article only, transparency obligations for certain AI systems. It's very important, for instance, to make it clear for chatbots to users that the chatbot is making clear in the initial statement that it is only a machine, a system, not a human. For other systems, the AI Act will not create any requirements. And it is expected that for about 90% of all AI systems, the AI Act will not pose any obligations. So that's very important to keep in mind, despite of the very broad definition of AI in the system. For the vast majority of AI systems, no obligations are created by the Act. If you turn for a minute to the concept on high-risk AI systems, it is interesting to see, just by looking at the titles of the different articles, that the AI system is trying to set up a comprehensive risk management systems regarding so-called AI systems, including of, for instance, a conformity estimates, post-marketing monitoring, reporting, and so on. Also, there will be supervision by authorities with very important powers. What is an AI risk system? I will come back to it in a minute. Do I really? No, I don't. I don't have a slide for this. I think I have, but I plan not to show it. The definition of high-risk system is mainly done by the way of two annexes to the AI Act. One part of the high-risk AI systems covered by Annex 2 of the Draft AI Act is what we traditionally know as a dangerous machine, such as a car would be high risk, also an electric saw would be high risk, and so on. So traditional machines. More interesting and more innovative is the Annex 3, which contains a list of of AI systems, mainly software, which are important for the use in decision making, such as access to universities, such as access to jobs, such as the use of AI systems in the judiciary or public administration. This kind of use cases of AI have not been covered by risk management regulation so far. So that will be a rather new and interesting concept, and it addresses all the concerns on AI which have been mentioned in the short introduction this morning. I already mentioned that the Draft AI Act is addressing the manufacturer or producer of an AI systems under the heading of the notion of a provider, as well as the user. And it's interesting, in the Commission's draft, the AI Act was intended to address only professional users. The Council, however, is including even private users. Let's see what will be the final version. What is interesting is that the user of an AI system is obliged to use the system only in accordance with the instructions of use accompanying the system. If they go beyond it, they will be considered a provider themselves, which is a huge risk, then that would come back with a violation of risk management duties, possible fines, and so on. So the user is strictly bound to the instructions of use, which is, in my view, a consumer-like role, which is interesting since most users of AI systems will be professional users, such as companies and so on. Now, as I only have a little time for my today's presentation, let's turn to liability, which is in the focus of the European legislator. First of all, let me explain in a few words the background against which the European legislator is introducing potential new legislation. There are some gaps in the current liability systems, I think, and why is it so? Just because, in my view, AI systems can show behavior, and I define here behavior as the ability to choose actions depending on a perceived situation, which the good old steam engine could not do. But we expect it's exactly doing this from a self-driving car. It should choose its action, its further functioning based on a perceived traffic situation and on a situation which it does itself based on the information it itself is perceiving. And that gives rise to some gaps in the traditional system. Traditionally, tort law is restricted to liability caused by fault. And fault is defined in most jurisdictions worldwide as intent or breach of a duty of care. And for this reason, fault requires human behavior. We do not apply tort law to a machine. If, however, an autonomous system will cause damage, so if the damage is caused by machine behavior, we do not have a fault of a machine, since machine is not fault of culpability, but also we do not have a human fault, since the human is not doing anything in this moment. And for this reason, systematically, there is an important gap in the traditional tort law when it comes to the use of AI systems. And for this reason, the legislator was called to intervene, for instance, by the European Parliament and also by many authors, and also by the expert group on liability set up by the European Commission. One of the answers given by the Commission is the draft AI liability directive, which was published last year. I guess I have another 5 minutes, since I was starting a bit later. Just give me a signal if I should come to an end. Interestingly, the Draft AI Act is a rather short piece of legislation comprising of only 9 articles. Remember, Draft AI Act was 85. It has only 2 elements. One is the Article 3. It's a right to disclosure of evidence, which can be understood as a discovery or as a in a different way also. And also, it contains a rebuttable presumption of a causal link in the case of fault. What it does not do, and that's interesting, it does not comprise an independent legal basis for liability. It does not set up any monitoring duties on the part of the provider or user of an AI systems. In my view, this is very limited. I skip the details of the presumption just for the sake of time and come to a very short summary on the AI directive. There are some interesting measures to improve the enforceability of tort law claims. Unfortunately, I do not have the time to demonstrate it in detail. What I want to say is it does not close the gap in the liability regime with regard to AI systems. And therefore, we have to look further to other instruments. And then that might be the draft new product liability directive, which was published the same day. So they come as a package. And that's interesting. Now let's have a very brief look at the content of the new directive. I skipped the overview by saying that the draft new PLD, product liability directive, which is deemed to replace the current product liability directive from 1985, will be the new legal basis for what we call product liability. What is product liability? It's a liability of the manufacturer for faulty products. It's very important that this kind of liability does not require a fault or a duty of negligence. It just refers to the existence of a defect into the product which is causing a damage. First of all, by way of a new Article 4, product would include software explicitly, which means the new PLD would be applicable to any kind of an AI system. So we are full in. So, and the principle, the right to compensation will be the same as in the previous or in the current product liability regime, saying that a person who suffers damage from a defective product is entitled to compensation. And a product is defective when it does not provide the safety which the public at large is entitled to expect. That's a basic principle of product liability. I skipped this one, even though it's interesting. And I would like to focus on a very interesting element regarding the burden of proof. According to product liability law, the claimant, which is the injured party, has the burden of proof. So the claimant is required to prove the defectiveness as well as the causal link between the defectiveness and the damage. And that's very difficult in the case of an AI systems. That's why the shifting of the burden of proof is crucial in the case of product liability for AI systems. And here, the paragraph 2 of Article 9 provides a very interesting solution. According to paragraph 2, the defectiveness of the product shall be presumed in some cases, including literal C, in the case that the damage was caused by an obvious malfunction of the product during normal use. And this is thrilling in my view, since an obvious malfunction product is covering, in my view, also faulty behavior. And if you take the example of an accident caused by a self-driving car, the causing of an accident would be an obvious malfunction, and that would give rise to a presumption for defectiveness of the product, which would be enough to trigger liability. So if we interpreted Article 9 this way, and this, in my view, is exactly the intention of the European Commission, then we would have a very important basis for liability for damage caused by AI systems. That's why my preliminary evaluation of the new PLD is totally different from the one of the draft AI liability directive. In my view, the proposed changes to product liability are of key importance for AI systems. There's, however, a risk which is not covered. This is the so-called development risk. Unfortunately, I don't have time to come to it. But as a very brief conclusion, I would like to say here that the law, in my view, should and has to address the specific risk associated with AI systems. And obviously, the draft AI Act is an important element of the new legal framework for AI systems. And with regard to liability, which is certainly a cornerstone of the legal framework, we have to see that the gaps in the liability are not closed completely by the current proposals, in particular not by the draft directive on AI liability, whereas the draft new product liability is in an interesting way focusing regarding liability on the manufacture of an AI system, which I think is adequate. However, as the gaps are not closed and as there are many questions still open, the development of an adequate legal framework for AI must go on. Thank you very much for your attention.